called Transparency, Using It to Your Advantage. Want to say, first off, a couple things. Today is the first day of spring. It is a balmy 28 degrees today.
Yeah.
So folks out there, just so you know, I have a pool, and every year my goal is to be the first person literally in my town to open the pool, right? I have it April 1st. So for those of you in Texas, I apologize. I know that right now you're like, what do you mean? Everyone's pool's open. Trust me, my goal is that April 1st is when I open my pool. I'm embarrassed to call my pool guy. I've been delaying it every day. I just don't call him because what am I going to say? Hey, JJ, can you open my pool even though there's 3 feet of snow literally on top of it right now?
You got to break through the ice.
Because we're getting another foot of snow tomorrow.
Nor'easter number 4.
Again, the bomb, cyclone, nor'easter,
snowpocalypse, snowmageddon.
We're getting another foot of snow tomorrow. It's wonderful. I think 2 months ago it was 75.
Yeah.
I remember that, right?
Oh, yeah.
So we apologize, folks, if we're just sick of being inside. I think that's what's happening here. So we apologize if we talk way too fast today. We all just need to get outside and maybe go down south. Speaking of, my wife and my 2 older kids, the 4-year-olds, went to Florida this morning for the rest of the week. So I am on daddy daycare duty taking care of the 2-year-olds on my own for the rest of the week.
Just in time for the power to go out tomorrow, Adam?
Just in time for the power outage. It's going to be awesome. Anyways, I'm being very transparent. That's why I figured I'd tell you my life story. But today we'll have Ron Peck, as always. Say hello, Ron.
Hello, Ron.
Brady Bizzarro, one of our top attorneys here. You know what? I hate the fact that we just call him a staff attorney. But I guess that's all he is.
He's Brady. He's the GOAT.
The staff attorney.
He's the GOAT, right?
Brady Bizzarro. Say hello, Brady.
Hello, Brady.
And, of course, the reason why everyone tunes in, they look at that photo and they just dial in. Say hello to Jen McCormick. Say hello, Jen.
Hello.
I do appreciate the power pose, Jen.
Yeah.
The power pose.
You know me.
So today, folks, don't forget, please follow us on LinkedIn. Go to your LinkedIn page. Look up the Phia Group. Remember, Matt is a week away from losing his job. # save Matt. He thinks I'm joking.
I think he
will be terminated.
I honestly think it might be too late.
If we don't have 3,000 followers, I think we're at 20, what? What are we at now?
It's almost 26. Yeah.
So we're at 2430. Folks, just so you know, Matt originally asked for, is there sound? Matt originally asked for the number to be 2,500, and I said that's way too easy. We're almost there now, without Matt even begging anyone to sign up so that he would keep his job. So we're about 570 short of reaching our goal, and hopefully Matt will be able to send his resume out and find some people that would want to hire him.
Sure.
But, we tried. Matt, we made a big effort. Great effort. We still got 2 more weeks. So anyways, feel free to follow us. I'm going to turn it over now to Jen McCormick. As always, we want the Phia Group's consultant department. We have our top 10 typical questions. We try to narrow it down to about 3 so we can go over it during our webinar and give some of you some free information and advice. So with that, I'm going to turn it over to Jen.
All right. Thank you very much. So question number 1, can a self-funded plan include a binding arbitration clause? If so, what effect does it have? So as with the good, there's always the bad. Can you include this provision? Yes. However, remember that while arbitration can actually be very helpful in resolving disputes and efficient in resolving disputes, at times it potentially can be expensive. So with the pros, there's the cons. So the pros generally are cost. It's generally less costly, more cost-effective to use arbitration as opposed to litigation. We're attorneys, we know that here. Time. Generally, it's much more time-effective, too, if you're using arbitration as opposed to going to actual court and litigating. There's a ton of steps when it comes to litigation. And with arbitration, you can avoid all of those steps. Next, discovery. Arbitration is going to have some more relaxed rules. So you're not going to have to be dictated by the particular rules in the court or in the jurisdiction if you're using arbitration instead of litigation. Last, it's confidential. So the results of an arbitration will be confidential, which is not necessarily the case if you go to court. The cons. So I know that I said that arbitration could be more cost-effective. There is the opportunity where it potentially could be more costly. It really depends on the facts and the circumstances of the case. If there is a situation where you have an individual who is party to the arbitration who is going out of their way to be uncooperative because they're required to do this, maybe this could take more time. You have to take a look at the actual parties involved and see what their motivations are. Are they really looking to resolve this matter? So keep that in mind too about when you're looking whether or not a binding arbitration clause would be effective. It depends on the type of the dispute. It depends on the cost. So this is something that could be very functional and be very cost effective. The theme of our webinar today is about transparency. So having an arbitration provision, even if it's not necessarily mandatory, could be cost effective, and it is transparent in what it is that arbitration will require as opposed to litigation. Number 2, how do jurisdictional provisions work in contracts? So there's generally 2, a choice of law and a choice of forum. So with the choice of law provision within a contract, that's where it's going to say something like the contract is governed by X. So when we're talking about plans, guess what the contract is not governed by? ERISA, because ERISA is the federal law that is going to dictate the health plan and the benefits, not necessarily the contract itself. So when you're looking at a choice of law provision, you should make sure that it's relevant to the actual state. There needs to be some sort of relationship to the actual state that you're selecting for your choice of law provision, whether or not you're located there or the parties do business there. Obviously, that's something to work out with your own internal legal team. The other type of choice of law provision that we see are a choice of forum provision. And this is really actually just where the dispute's going to be heard. So this is really going to matter if you're talking about the particular laws that might be in effect. So if there is a case and there are better laws in Massachusetts than in Indiana, the choice of forum should be based on the state where there's potentially more impact. Last but not least, is a TPA required to provide a broker with access to a member's EOBs? And the answer is no. There's a difference between what.
How did that question come in? Just so I'm very. It's a interesting question. I thought I knew the answer to. I thought it was definitely a no. But
yeah.
People ask about this?
Yeah. So
how does this come up?
We're talking about transparency today. So some of the questions that we're seeing is that I want to know what happened. I want to know I want the data. I want the facts. So under HIPAA, that's what's going to govern us. If we're looking at a stop-loss dispute or a plan dispute, and someone wants access to this information, was there a copay? Was this subject to the deductible? What were the pricing parameters that were used from that particular claim? The broker might want to see it. They want to take a look and see if maybe there is an issue. But they're not required, the TPA is not required to provide that. It's a PHI issue.
Remember, the broker's client is the plan, right? Mm-hmm. So the plan could always share that information.
There's limited times when you're required to do something. Most of the time, you're permitted to do something. So that's the distinction here, is that there's a potential argument that you are permitted and it would be the right thing to do.
For business reason, right? You don't want to lose the client.
Right. But it's very rare.
It's not required.
It's rare that it's required. So keep that in mind. If you're running into a HIPAA type of situation, you're trying to promote transparency that's important to you, ask us if there's a question that arises. We'll take a look at the facts, and we'll let you know what our opinion is.
Ron? Yeah, it also may be the case, remember, anytime we're talking about PHI and HIPAA, there may be a reason why the broker needs the EOB, but it may be that they don't require all the PHI that would normally be in the EOB, and so it's possible the plan could provide some sort of, or the TPA could provide some sort of edited down version where it has the information that they need for plan purposes, but strip away the PHI that would be extraneous.
Right.
Right. Depends on the goals.
Exactly.
So
you can apply this to everything, right?
100%.
Access to a member's claims data, access to the plan's data.
Mm-hmm.
If you're able to strip away the PHI, why wouldn't you share it?
Question 1, what are you trying to accomplish? Question 2, what's the minimum amount of information you need in order to accomplish that goal?
All right. That's it.
All right, so it's back to me. So a couple of things I want to make sure I bring up. First off, folks, why do we do this? Our problem, purpose, and process. Then we're going to talk about with Brady. Literally, Brady can't do anything else other than the political update. Is that basically it, what he does here?
Honestly,
does he get paid a full-time salary?
More than enough to keep him busy right now. All
right, as long as you're sure about that. Last but not least, transparency. That word is the most overused word, in my opinion, in the industry. Here's what how I look at it before we get into the details. The fact that all of us in the industry, whether you're an administrator, a broker, a stop-loss carrier, a vendor, whatever, we have all these cool gadgets that we can look at. We have all this data we can compare. It doesn't matter if we like the tools. It doesn't matter if we use the tools. If the members don't act as consumers, if the patients aren't acting as buyers of care, none of the stuff that we're talking about matters. I can't tell you how many times I've had vendors call me and say, hey, we're the best tool. I'm like, who goes on the site? Nobody. Then what's it mean? It means nothing. The fact that the TPA thinks it's cool and that I think it's cool, but if a member isn't going on your website to compare prices, to compare quality, it doesn't mean anything.
It's a tree in the woods.
Right. We need to behave. It's true. We need behavior to change. So I tell people this all the time. I just bought a new car. For those clients, I'll say, yes, it's an American car. We always get those emails. I do not buy foreign. I am a proud owner. And again, I know a lot of people are going to not believe this. I don't drive a fancy sports car like, let's say Brady will one day when he starts making real money. I drive a GMC Sierra. It's a truck, okay? I love big trucks. I think it's cool, right? I'm not a Maserati guy anymore.
Waiting for that.
Anymore. That's when I add the word anymore. But the reason I bring this up is if somebody told me, hey, the copay for the new car is $100. Go to the dealership, pick out the car. I'm going to go to the closest one and just pick out the car. I'm not going to do any comparisons. I'm not going to go on Carfax to make sure the car wasn't in a car accident. I'm not going to Auto Trader, looking at different prices, where I can get a better deal. I'm paying $100. And that's how patients look at this. Their copay is the same regardless if they go to a $50,000 facility or a $10,000 facility. So the most overused word in the book is transparency. We're going to talk about how you can use transparency to your benefit, but also where it can hurt you if you're not disclosing certain things in a transparent fashion. Next. So we talk about this every month. We're trying to get this industry younger. I want more people like Brady, more people like Jen, the youngest old person I know. We have an initiative at SIA called the Future Leaders Initiative. I'm asking everyone on this call, please send a young person under the age of 35, I think it is? 35 to SIA. You get a discounted rate to go to the SIA event this October in Austin, I believe is where it is. I urge every one of you to send a person that otherwise wouldn't be going to that conference so we can get more and more young people, future leaders, interested in wanting to work in the self-funded industry. Why? Because every American in this country deserves access to high-quality, affordable health care. So with that, I'm going to turn it back over to Brady to talk about the only thing he can talk about for the next couple slides. Brady?
Well, thanks, Adam. I like the slide a lot because there's actually a national...
What is going on in the slide?
It's a showdown.
Is that Idaho?
It's Idaho, and it's President Obama or former President Obama behind it. Because there is a showdown going on over the ACA. You may not have heard of it. If you've been watching the news lately, you may not have seen it because a lot of the news, frankly, is filled with other topics. But there really is a big deal going on in Idaho. It's surprising and unlikely. We mentioned this actually briefly a few webinars ago, but essentially... in January of this year, the state DOI in Idaho announced that they were going to allow plans to be sold on the state exchanges which avoid ACA rules. Now, which rules? Well, the big ones. They wanted to charge sick people more for coverage. They wanted to avoid covering EHBs. They were going to bring back limits, annual and lifetime limits and caps on healthcare expenses. It's a big deal. Blue Cross Blue Shield of Idaho was ready to sell these plans starting in March. That was announced. It got some attention, but I think it should have gotten more attention. Eventually it did because other states said, hey, what's going on here? Can we also just avoid the rules? Now, you may be asking yourself on the call, well, what about the federal government rules? What about the Supremacy Clause or the Constitution? How can Idaho do this? Well, importantly, remember that, if you didn't know, the federal government cannot force state officials to enforce federal law. So think of the marijuana situation in the states right now, or immigration, another policy issue. The ACA, though, has a backup plan for that. And the backup plan is to allow the feds to step in and enforce the ACA if the state won't. So there was an open question. By the way, they've done this in other states like Oklahoma, Texas, and Wyoming. But once Idaho made this announcement, there was a lot of questions about what the Trump administration would do. What would the new HHS Secretary Alex Azar do? Would he allow the state to flaunt the rules, or would he come in and sort of drop the hammer? Or what would the courts do? Would they get involved? And it would have huge implications for the ACA and also for self-funding, because then self-funded health plans could pick a benchmark plan in Idaho, right, that didn't have to follow all these ACA rules and just sit back and say, well, we don't think the feds are going to enforce this. So you'd have essentially a race to the bottom where before you know it, you'd have a bunch of plans being sold in both the individual market and the employer group market, which were not following ACA rules. So The showdown was over that, and just recently, surprisingly, the administration did step in and issued a letter to Idaho's governor and to their state DOI saying, hey, you have to make sure you're following the ACA. This is not the way to go. They warned them that, there'd be some serious fines involved if they kept doing this. So Obamacare does remain the law of the land, but importantly, there may be a workaround still, and this has to do with one of the executive orders that the administration issued late last year regarding both short-term health plans and association health plans. So the proposed rule on short-term health plans, as a reminder, was issued on February 20th, basically saying it extends the duration of these plans from 90 days to 364 days. That's a long time of duration. And these short-term plans are not subject to EHBs. They can screen people who have existing medical conditions. They can impose annual and lifetime limits. So the increased use of short-term plans will probably have a negative impact on the individual market. Same thing with association health plans. In our industry, we've been following this as well because the rules have been relaxed to allow more small business owners and self-employed workers to band together, where you didn't have to be associated with the same industry. Now you can be in different industries and band together to sell insurance.
All right, so on this, I want to get to the real one here, the short-term plans I think is more important. The association health plans, obviously from a self-funded standpoint, it's a benefit to our industry because it's a lot, again, I always tell people, what's the perfect size to be self-funded? There is none, right? You can be one person and really healthy and super rich, you can be self-funded. But obviously the smaller group you have, the tougher it is to buy stop loss. Let's be honest. If I had 5 healthy yoga instructors who are in perfect shape, let's say 5 Jeds, right? Perfect shape, young, energetic, always working out. Great. Don't have a lot of claims. The hard part could be finding a stop loss carrier. You're too small. So banding together would allow you to band to purchase stop loss, I'm assuming, right?
Yeah.
Good. The short-term plans, it seems to me, you mentioned the word, it's going to hurt, what did you say?
The individual market.
Why?
Because you'll have, in theory, healthier people will opt for these short-term plans that have skimpier coverage, and you're going to leave sicker people in the individual pool.
But why? Why would they sign up for this coverage? Why not? Why have any coverage?
Because they have to, because the mandate's gone, so they may not have any coverage. But those who do want coverage,
so you're telling me if I'm Jen, okay, 35. All right, I'm really pushing it. I don't know why I'm treating her so nice today. 35, perfect health, no history in my family of any medical conditions, and I don't need insurance at all. I'm going to say, wait a second. Instead of having the typical health plan like I have at Phia,
right,
I'm now going to have a short-term plan that's going to give me coverage for 90 days or 6 months that can have annual and lifetime limits. Why? Why would I wouldn't I only want insurance if I'm Jen that's catastrophic? Isn't the whole point of a Jen needing insurance being like car insurance, right?
Yes.
My car insurance doesn't have oil change coverage.
Right.
But I have, knock on wood, if an 18-wheeler just decides to text and not look at the red light, I freak out every day on Granite Street about this. I really do, driving home, okay? I mean, it's because I have all these kids. That's why I think about it. But I want insurance so when my car's totaled. So if I'm 35, wouldn't it be I just want to have health insurance in case something really bad happens to me?
Yeah, you're talking about unforeseeable, catastrophic risks that you can't afford to take on yourself.
Why am I buying something that has a lifetime limit and an annual limit and doesn't have essential health? Like, is that what these plans are catastrophic type plans?
Well, so they can be modified basically. They can cover what they want. They don't have to cover all the EHBs. So whatever ones they pick, you can cover. So maybe someone who wants to have just checkups once a year wants a plan that just.
Well, why even have that? Like, we just pay for checkups cash? Like, to me,
right.
You're telling me right now in the open market, Ron and I can start a new company and say, we're going to offer, it's going to be Jen coverage. You don't need us for your office visit. You don't need us for your urgent care visit. You just need us in case you got a large, whopping hospital bill. We're going to take care of that one big bill. That's it. That's the coverage.
Right.
Could that fit under this rule, under this model?
Yeah, I mean, the rule hasn't been finalized, so I would say probably yes, because it can be very flexible.
Sorry, I didn't mean to jump on your parade, but when you mentioned that it's going to hurt the individual market, I'm like, really? Is it?
Yeah, well,
that was my concern.
The fear in both these cases is that you'll just have sick people left on the exchanges. And so, we'll see how this develops, but I think in either case, the markets, the individual markets are already struggling as it is. But I want to note really quick before I move on to the next slide, a special individual mandate I saw in the news the other day. I want to almost call it the supercharged mandate. So Connecticut is following the lead of other states now by proposing to introduce their own state individual mandate, and theirs is going to be increasing the penalty for not having coverage from 2.5% to 9.6%, up to $10,000. So that's a lot of money to pay in a fine for not having coverage. But people are calling it the supercharged mandate.
Connecticut's trying to get more people out of their state, huh? We just took over all the business from GE. It's all moving here.
Right.
I mean, they're just doing everything they possibly can to lower their population. What are they trying to be, Wyoming? I mean, what are they doing? I mean,
they really want you to have coverage.
I mean, just move. Anyways, okay, go ahead.
So one last thing on this, and this month's important for a number of reasons in Congress, one of which is we're facing yet another specter of government shutdown this Friday. Congress is struggling to pass a final spending bill, $1.3 trillion. And surprisingly, or not surprisingly rather, healthcare is one of the sticking points that could cause the government to shut down here as a holdup, because essentially there have been a couple of stabilization bills for Obamacare that have been sort of pending in Congress. One, the Alexander Murray bill and the Collins-Nelson bill. Essentially, both of these bills are efforts to provide billions of dollars in federal money to the exchanges to stabilize them. Because you remember, we mentioned this at the end of last year, that the government ended these so-called cost-sharing reduction payments to insurance companies, which really destabilized the pools even more. You had people pulling out, fewer insurers left, and so money is needed. But the new twist here is that the White House has added some conservative demands. They say, if we're going to stabilize Obamacare, which why would we want to do anyway, we want you to pay for the wall, for example. So we'll see what happens. Hot button issues to follow, but Obamacare is in the crosshairs, and we'll see how it resolves literally this week.
Brady, thank you so much. Before we let you off the hook here, there's a couple questions I want to bring up that tie to what you have to talk about. Are early signs in the association discussion limited to small business and individuals? How might multiple mid-size employers, again, I always love the word mid-size. What does that mean?
Yeah.
But that's okay. Any suggestions that these arrangements would be subject to MIWA requirements? Any feedback or thoughts on that?
So I would just say we're still waiting on a final rule on association health plans, and I know SIA has been watching for this as well. As I understand it, I'm not sure if there's been a number placed on what size employers must be to band together. I just know that what the guidance suggests, the rules will be loosened. I'm not sure we have a number on that yet. And then as far as the MIWA question, that's also, as far as I know, still up in the air. Maybe Jen has some more thoughts on that because you just wrote something on this issue.
Yeah, so that is one of the issues that people are concerned about. If you're having an association health plan, technically it's a MIWA, and the MIWA requirements are outlined by state law. So every state has different requirements about whether or not you can have a MIWA. So that is something that these types of associations are going to have to be cognizant of. There are different requirements, too, for some states. Minnesota and Ohio, for example, they don't necessarily have MIWAs, but they have similar types of organizations with very specific regulations. So while this is an opportunity for the self-funded industry, you have to be careful about the particular laws in the states where you're trying to establish such an association health plan. We'll wait and see.
And also just, Brady, you mentioned that SIA is one of the organizations that have been looking at this, and I can actually tell you that, in particular, the Government Relations Committee at SIA has been looking at the proposals regarding the association health plans, and one of the topics that they've been looking at, so kudos to the person who submitted the question, is the impact of MIWA regulations and state-by-state regulations, especially if you have an association health plan across state lines. And so will there be sort of one federal set of rules, or do you have to comply with all of the states that you're in, or do you pick your home state? All these different questions are things that have been brought up to the regulators. If you have questions or concerns regarding association health plans, or really anything for that matter, go ahead and submit it to us. If we don't get to it today, I apologize. And if it's something that makes a lot of sense to then bring to SIA, I know that they would value that feedback as well.
All right, one last question for Brady before we move on.
Sure. I don't want to get too far in the weeds here, but I will address this last question asking if they, I presume that means Republicans, want to see the demise of the ACA, why they support the situation in Idaho. And I know on the president having multiple personalities, which may or may not be the case. But I can say this on the ACA, I think the issue there is I assume what was told to the administration is, hey, look, you've got federal law not being followed by states. It's important for other policy areas that we have states following federal law while it's there. Again, maybe the marijuana case is an exception. I think also the fact that there's an alternative route around this, right? Offering short-term health plans or association health plans will essentially allow Idaho to achieve the same goal in the end without having to flaunt federal law. So that's why I think Republicans went along with the administration and forced them to sort of comply.
Great work, Brady, as always, on the one thing you do know here at FIA. With that, Jen, let's turn it back over to you. Pricing transparency for the plan.
All right, so now we're going to dig in a little bit more to the different types of transparency that we see when it comes to plans, health plans. So pricing. What does pricing mean? So when we're talking about pricing, there's lots of different ways when you're trying to decide whether or not something is transparent. But where do you start? Well, you start by looking at how it's defined. So when you're looking at how transparency, how the payable amount, max allowable charge, UNC, reasonable by whatever term that you use in your particular document, how is it specifically defined? Or is it? So it's very possible that certain parameters that are being used for the payable amount, it's based on a network. Maybe there is no actual language within the document itself that defines the payable amount. By having that defined by whatever parameters, how few, however many parameters that you want to use are going to be key. It's important for you, not only as a plan administrator, but as a fiduciary, to prudently manage the assets of the plan. And in order to prudently manage the assets of the plan, you have to be paying according to the parameters that you have set forth within the document.
Right. What if the document you have language in there, sorry for doing this, but I just think it's all a bunch of BS. If you have language in the document that says, yeah, we're going to pay based on the typical charge in the area, is that okay? Because you're following the terms of the plan. You're being transparent. I'm transparent in the fact that I'm going to just pay whatever they ask for.
I think, and
is that okay?
Adam, this is actually a really good question.
I mean, we can talk about this for an hour.
I was going to say
we can't do,
and
but
it's funny because stop loss has brought this issue to our attention as well. Where
right, you're following the terms of the plan.
You're putting in your plan, but it's so ambiguous. How can stop loss, for instance, during underwriting, calculate what you're actually going to be spending in these instances?
I think this is an example. Sorry, Jennifer, jumping on your slide, but this is an example where the plan needs to be careful in that it doesn't just say, we're going to pay whatever the typical charge is. I mean, we see 75% of the plan docs that we see, guys, say that.
Mm-hmm.
Right? We're going to pay whatever they charge. And that's transparent. We're following the terms of the plan. But the day is coming. The day is coming where a member of a plan, of a union plan, who's getting killed every year on premiums and out-of-pocket expenses, is going to look at this and go, how in the world can you pay so much for these claims?
It's arbitrary.
That's so sorry, but go ahead.
No, so that's the point. So when you pair whatever the parameters that you use, and I'm hoping that you're not just saying whatever the plan administrator deems to be reasonable. If you do, call us. You need to pair that with actual discretion. There needs to be some sort of basis of evidence, reliable feedback, parameters that you're using to decide what's reasonable. And that goes to the point that Adam and Ron were just talking about. Stop loss is going to push back. If you're not using some evidence, some basis for how you're calculating your payable amounts within the plan document, wouldn't you expect pushback? And I'm sure we all remember this case because we keep talking about it, the Macy's case. There are opportunities where people are trying to take measures, they're trying to input solutions for how they can discourage an abuse of how something is being calculated, how something is being paid, whether it's a vendor or other parameters that they're actually using. And if that is the case, that language needs to be in the plan. Whatever parameters you're using, whatever evidence you're using, whatever basis you're using for calculating your payable amount, if you don't put that in a plan and you use those parameters, as happened in the Macy's case, you're going to get sued. Because not only are you failing to abide by the ERISA notification requirements, you're breaching your fiduciary duties, which is a real problem.
I just think, this is really important stuff, how it's tied into the plan doc, but the problem we see every day, people spend so much time making these plan docs as perfect as they can, rightfully so, and then just give it all away with the network contract, where they have no right to audit, they have no right to do any of the things that we're talking about, whatever you want to put in this black box, whatever you want to talk about discretion, whatever you want to talk about pushing back, whether you want to call it some type of cost-sharing provision or cost containment language, it all goes for naught when you sign the wrong network contract.
Adam, it's actually interesting you bring that up because as people have been submitting questions, I was going to try and address them at the end, but it's almost parallel to one of the other answers I was going to give. Somebody asked earlier when, Jen, I believe you were the one talking about getting data and being able to use the data. And we got into the conversation about the EOBs and what do you have access to and things like that. And the question was, well, if I have a right to this data as the plan, how can a BUCA, right, or a carrier withhold that data from me? And that was the question. And it's exactly the same issue as the PPO issue you just mentioned. Again, it's the contract. So whether you have a right in the plan to do what the plan says, or you have a right under law to use the data, either way, you can always give away or limit one of those rights with a contract. So your rights under the plan, you're limiting those rights that you had with a contract. Your rights to your claims data, you're limiting that right with a contract. So again, just because you have a right initially, if you contract away that right, it's gone.
We have to make a rule that we can't answer any more questions. We've literally never received this many questions ever. I guess it's hitting.
They smell blood in the water.
Well,
she's answering questions.
Transparency freaks people out. It brings a lot of the best out of people. But
it's racy. It's a very exciting topic.
All right, Jen, what do you got?
All right. So next, notification requirements, right? So it is going to be crucial. We were talking this about a little bit earlier to notify everyone about how the parameters that you're using, you're actually pricing the claims. As we talked about just a tiny bit, it's nearly impossible to have the tightest plan language possible for the parameters that you can use to ensure there's no excessive charges, and also have a network contract at the same time. So there's potentials to be conflicts between all of the varying different documents. So you need to do the best that you can to minimize the conflicts, minimize the gaps between all of the plays, all the contracts that are at play here. So when it comes to stop loss, one of the things that we have done to help tighten up the language, to tighten up the opportunity where if a plan is using parameters that they are having the maximum of discretion allowed that wouldn't put the stop loss carrier in a bind, we've modified some of the definitions in our document so we can help with that problem, make sure that the notification, the underwriting, everything is going to be handled appropriately and everyone is aware of what the notification requirements are. And even more than that, when we're talking about notification, forget the actual contracts, the vendors that you might be using. There are ERISA requirements too that you have to abide by. So if you're making changes to the documents, you're making updates to how the plan is actually pricing the claims, you need to tell the stop loss carrier and, importantly, the plan participants. They're the ones who are going to matter the most because they're the ones that are actually seeking the treatment. Maybe there is an opportunity, and I know that this is really going to be dependent on the actual population of employees that you have, but we're talking about transparency. If the plan members don't realize the impact that their decision to go to the Maserati dealership down the street versus, I don't know, in
the Subaru dealership.
If they don't understand the difference between the two, then why is it their fault for not making the right decision? When we're talking about transparency, it's important for everyone to know what's going on. Only with that education, that advocacy, can we make the right choices. All right. Does the plan have any sort of unwritten internal policies? So this first one has really become a hot topic lately, site of service pricing. This is actually something that we have done here internally at Phia to advocate using the right prices. So this is a situation where an individual can receive the same treatment. So maybe you're receiving a treatment at your cardiologist as opposed to a outpatient hospital or freestanding facility. The same X service is being treated and billed differently based on where you're actually receiving the claims, where these charges are being incurred. Why is the price higher based on the facility setting versus being in a medical provider's office if it's the same exact service? So take a look at the actual policies, the procedures that you have. Is that something that's in place? Is that part of the network agreement? Is that something that you can actually have an impact on by encouraging people to go to X facility as opposed to another facility?
If you're a broker or an administrator on this call, this is where you can make a big difference, where you can show whereas another broker or administrator would not be able to give you any insight onto this. This way you can really show your expertise and that you're trying to save that to your particular client additional money. The site of service pricing is a huge area where you can really show more bang for the buck.
Right, and this is unlike the other situations when you're making a choice about this versus that procedure, it's the same procedure. It's the same service. So it doesn't matter where you get it. If you can be incentivized to save money based on going here versus there, why aren't you doing it? Why aren't you encouraging people to make that choice? Next, All right. Pre-certification for RX drugs. So the RX drugs, prescription drugs, specialty drugs, they're expensive, right? So what can we do to encourage this transfer? Are there rules where maybe it's unwritten that if you need X drug or Y drug, there are certain pre-authorization requirements, there are pre-certification requirements, notification requirements that don't necessarily exist? If so, is the application of those pre-certification requirements discriminatory? Are you treating people who have a certain condition or disease differently, maybe even accidentally? If that's the case, if you do want to look for cost savings, you want to look for opportunities, maybe you should put pre-certification requirements in the plan or in the way that you're actually administering the prescription benefits. Last but not least, unwritten medical necessity criteria. What are you using for making determinations about medical necessity? Do you have a UM vendor, a CM vendor who's making decisions about how claims should be written and whether or not something should be medically necessary and covered under the plan? If so, if you're using that criteria and maybe it's questionable, maybe it's a potential problem, there's the opportunity, if there's an appeal, if there's something that was denied based on medical necessity and you're using this unwritten criteria, you potentially could lose in the case of an appeal because you don't have documented procedures for how you're going about those medical necessity criteria and making those claims decisions. So it's going to be key, if you're using any of these policies, any of these procedures, make sure they're written somewhere. Have it documented.
Good job, Jen. Ron?
So before we continue and talk about one of my favorite topics, right, drug purchasing, I'm just kidding. One of the housekeeping items, I know some people have commented that the audio is dropping out. If you are listening to the audio through the computer audio on the internet, feel free to mute that audio or reduce it and dial in using the phone number. I believe that was provided with the invitation as well. The phone audio should be working fine. I apologize for any technical issues that may have caused. So quick, let's talk about PBMs and drugs in general.
Hey, Ron, earlier this week you did a podcast with our good friend LG Hansel, correct?
That's right.
And I'm assuming this was a part of that discussion.
Absolutely. It's very timely. And actually, I think it inspired us to include this in the discussion of transparency. And the timing couldn't be any better. I know the president was just visiting our neighbor to the north, New Hampshire, to talk about drugs. So it's definitely a hot topic. I feel like when it comes to contracts and transparency, the one issue that just keeps popping up and people literally just get so confused and frustrating that they just throw their hands in the air and say, you know what, I'm going to go deal with the PPO contract instead, is the PBM contract. And I believe it's because with PPOs, love it or hate it, want to get rid of it, change it, or keep it. Ultimately, I think people understand at its core what a PPO is supposed to do. I think that too many of our clients and benefit plans and those of us who service them don't even understand what the role of the PBM is in the first place. And as a result, if you don't even know what they're supposed to be doing, how can you look at their contract and say that something is right or wrong? So the first issue is understanding what they do in the first place, which is what a PBM does. Secondly, once you've determined what the PBM should and shouldn't be doing, then you can look at the contract and determine A, what's an issue that needs to be fixed, or B, where is there a lack of transparency? You know, one of the things that we often look at is, for instance, handling rebates, right? Who's getting the rebate? How are they earned? How are they delivered? And you don't even know that there's actually more than one type of a rebate. Some of the rebates will go back to the plan. Other rebates go right back to the PBM. Did you know that? I don't know. Is it in the contract? I don't know. Transparency. Another issue that was brought up during the podcast, and I definitely suggest those of you who haven't listened in, go to our media page, YouTube, Podomatic. It's on the Apple iTunes store, and listen to this podcast. One of the interesting issues that LG brought up is the fact that a lot of these PBMs actually, they receive a financial payout, an incentive for the number of times that they distribute drugs. And in fact, often the organization that owns the PBM owns the distributor as well. So now there's two financial incentives to distribute the drug. So if the drug is not covered or should be limited by the plan, there's actually potentially a conflict of interest there because they're incentivized to distribute more.
Right.
So it's just so many issues. One, again, understanding what the role of the PBM is. Two, looking at the contract with eyes that are now informed. And then three, addressing these potential issues and concerns. And remembering, again, that the PBM is not necessarily supposed to be your advocate. They're in the business of receiving the claims, distributing the medication. They're not necessarily there to try and contain costs on behalf of the plan. Once you understand that, I think you'll be able to read the contract more accurately.
So what we're trying to say is make it maybe a goal of yours to learn more about what the PBM industry looks like and what type of contracts you're actually signing right now, because probably that is the area where there's the least amount of transparency that people don't realize there are better alternatives.
If you don't know what they're supposed to be doing, how can you call them out for a lack of transparency?
Right. Good point, Ron.
Thanks. So speaking of people who we actually do know what they're supposed to be doing, and that's why we read their contracts and crush them every time, are the PPOs. I almost feel bad. I mean, the network, it still, I guess, provides some value, and we tend to sweep that under the rug until people are being balanced bills, and then all of a sudden we say, hey, remember the days when things were under contract, people didn't get balanced bills. But there are other issues that I think definitely need to be addressed when we look at the PPO. One of the biggest issues that I've run into, and Adam, we already talked about the fact that you're contracting away a right that you have under law.
I don't think we need to focus on the auditing claims or the provider contract.
Those were rights that you had that you contract away.
DRGs,
that's the biggest issue.
The DRGs kill us.
DRGs kill us. And the thing is, you don't even know what it's going to be until it comes in. This is one of those things where you're signing off because you have to, at least in your mind, you think you have to, and then the claim comes in, and now it's too late to do anything about it. And I love the people who whip out the plan document and say, but the plan document put the usual customary cap, or, I don't have to pay more than the bill charges. And maybe you're right. Maybe payment of this claim is going to violate your plan document. Maybe you're violating your fiduciary duties.
Whoa! In all fairness, right? Because I still see the emails where we're asked by a client, should we pay this DRG rate? It's 3 times the charge. Mm-hmm. Are there examples where they're saving a lot of money on the DRG rate? Is there a comparison being done for full transparency? Going, yeah, you're right. We're overpaid on this one, but you realize that we save money on these 20.
I mean, that's generally...
Is that what the point of this is?
That's the proposition. That's what's presented.
Is that shown to people?
Well, I don't think it is. And that's the thing. People are going to get data that indicates, hey, overall, here are your savings with the network. But I don't think that they're showing them, net after the DRG payment. So the problem is, on the one hand, I'm getting a 30% discount, la-di-da-di-da, but I don't know what actual dollar savings that's resulting in. But then I get this one DRG claim, and I'm really confused, and I'm saying, the bill is $20,000, and I'm being charged $40,000. What's that about?
So how that stop-loss carrier is going to treat them and their policy transparency, I guess you can bring it right back to Brady. You're going to talk about that next, right?
I am, yeah. So contrary to popular belief, I actually do have something to say about transparency, not just politics, but in this regard, it's about stop-loss and stop-loss contracts.
So the politics of stop-loss.
Can he get a ring?
It could be. So the important thing to know, first of all, is that stop-loss policies are just one part of stop-loss coverage. Keep in mind there's an application, there's a proposal, there's a disclosure statement, and we've seen these issues before. So be sure that when you are signing off on a separate document that you know what it says, because you could be agreeing to things that aren't actually in the stop-loss policy itself. That's the first thing. But these bullets here are meant to cover a few of the big areas that we see all the time, and one of the biggest ones, of course, is how the carrier is going to treat UNC. So are they using prevailing charge in the area? Are they they usually are relying on different nationally and regionally adjusted data. So if you're not sure what they're going to base their reimbursement on, then you can't be safe that your plan doc is enough to protect you. Ask the carrier how they're going to treat these out-of-network claims. If you don't know for sure, you could find yourself being sorry later on.
So what I've been noticing is, and one of my good friends who's on this webinar, who likes to ask a lot of questions, and one of the smartest guys I know, always brings up this idea, like he's been bringing up the idea recently of this carrier on reference-based pricing plans limiting RVP reimbursement to 250% of Medicare. And I look at that and say, that's transparent. At least they're telling you this is the most we're going to reimburse you is 250% of Medicare, where most of the policies that we see when it relates to reference-based pricing from a stop-loss perspective are like, oh, well, we'll see if we'll reimburse you if you decide to pay more than 140 of Medicare. So, again, I know it's especially important for RVP, but stop-loss carriers are being more transparent, I believe, now. When they say this is what we're going to deny, these are the claims that we're not going to cover, that's still transparent. It might not be mirroring the plan, but at least they're telling you what they will not reimburse.
It's bad
or
news.
Where they'll limit it.
It's bad news, but at least you're getting the news.
I was just going to mention, too, that the best carriers will have endorsements or mirror the policy. When you have that, it's pretty clear you do have transparency in that regard. Okay, a couple other things on vendor transparency. So important to note that it has been the case lately that state departments of insurance have been cracking down on undisclosed broker fees. So it was a case in California, this was an example. But essentially, these are in concert with aggressive consumer protection laws. They want to make sure that people know that there's a broker fee built in. And in fact, for brokers themselves, they want broker contracts to be very transparent about what the fees are up front so that employers aren't being taken for a ride. Is your broker submitting stop loss claims? First of all, is that allowed under your stop loss contract? If it is, are they following the requirements of a stop loss contract? Are they submitting claims timely? Are they following notice requirements? Do they know about large claim disclosures? You could get burned, in other words, by relying on a broker or some other third party to be reporting stop loss claims to your stop loss carrier. Make sure they're doing that correctly. Are vendors up to HIPAA snuffs? Remember that vendors, most of them are considered business associates, and you need to have a BAA with them because the HIPAA breach and non-disclosure laws apply to them as well.
One thing I would do, even we had to do this, we had our own general counsel. After years and years in the business, you start realizing you don't have BAAs or you have outdated HIPAA documents with some of these vendors. So take some time or contact us to take some time to look at ensuring that every vendor you're working with currently, you have a standard, up-to-snuff HIPAA documentation and BAA.
Yeah, because the regs are always changing. So one last thing on direct primary care, again, with those contracts, make sure that you're looking for fees that may be buried. Make sure that all the fees are actually just disclosed, and make sure you're not agreeing to things that conflict with your network contract. Very, very important there. One last slide here for me on transparency. I think this is actually very important because the Form 5500 is the dread for many people in the industry having to file those, but I want to point out that they've been modified slightly over the years, but a lot in 2016. Basically what's been going on is the DOL has been adding a few new disclosure points to this form. Disclosures such as fee and expenses of the plan. So they want to know what the plan is spending on for plan operations, for plan expenses, for prohibited or potentially prohibited transactions. The DOL wants to collect more data. The changes they made in 2016 to this form go into effect for plans starting in 2019. But importantly, I want to point out some of the bigger risk here, which is the fiduciary risk, because with all this big data that the DOL is collecting, and that's sort of been, many people are collecting our data these days, but the DOL has it, and when they have it, they can then use that data to target you for investigation to say, is this plan paying excessive fees, right? Or are they being transparent? Or are they engaging in transactions which they should not be? Is there some kind of self-dealing or conflict of interest? So essentially, the point to make here is be aware that you're going to be giving more information about your plans to the DOL in the coming years, and they're going to be using that. And finally, I want to mention on this point that this information is also public. So it's not just the DOL. This information will be posted online, and you could have plan members themselves looking through the forms and seeing what data they had. They could pull that data and put it in some kind of form and say, this employer seems to be paying excessive fees. We're going to file a class action lawsuit. The possibilities are kind of endless, and it's a brave new world out there with regard to big data. And on the Form 5500s, you're going to have a lot more data going forward. A couple other points here just quickly on EOBs and appeals. Again, make sure, this is obviously required under ERISA, but make sure that you're referencing particular plan provisions. Make sure you're giving a clear rationale for your denials, providing all documentation upon request in a timely fashion. If you don't, then you'll essentially be allowing plan members to skip your appeals process because it'll be deemed exhausted. So one last point here is CMS also is considering transparency as a way to contain costs. Who knew? We're all doing that. And with that, I'll turn on over to Ron for pricing provider transparency.
All right. So this one slide is standing between me and the topic that I really want to talk about, which is patient behavior. But anyway, this is actually a case study. This is something that happened. Somebody got a contract and entitled them to a case rate of about $55,000, and it was a really good deal, and they were very excited. We were too. And then they ended up getting a bill that was substantially larger. And it was only after they sent us the contract and we reviewed it that we saw that there was actually the greater of language, meaning it's a case rate of $55,000 or a certain percent of the bill charges, whichever one was greater. And you might not be shocked to hear that percentage of the bill charges was the higher amount. So again, you may be looking at a contract, see the number, and be drawn to it. But again, sometimes things can be right there in front of you and still not be transparent because they're hidden or camouflaged by good news. Don't be drawn by the shiny. Look for the underbelly. Now, the topic that I really want to talk about, which is the patient transparency, it's interesting because as a preface, I just want to say, I'm not against price transparency, okay? For those on social media who have been crushing me on some of my more provocative comments, that was just to draw you into this webinar. I'm not against price transparency, I'll say it again. But just like any other tool, if it's not part of an appropriate package of services and people don't understand what to do with it, it could cause more harm than good. I view price transparency as one part of a three-part solution, okay? Price transparency is one, but quality metrics, quality transparency is two, and skin in the game on the part of the patient is three. If you don't have those three parts, you could be dealing with some trouble. So, what do I mean when I say that you could be dealing with trouble? If you just give people the price information without the skin in the game and the quality metrics, going back to Adam's example that he gave us very early on about purchasing an automobile, he indicated that if I've got a $100 copay, I'm going to go to the closest dealership and buy what's there because of convenience. Convenience is one thing. But now with price transparency, I tell you what every vehicle costs. Hey, Adam, this truck is $50,000, that truck is $80,000, and that truck over there is $160,000.
I'm assuming if I can get them all for $100, the $160,000 one's the best one.
Oh, yeah, there you go. Hey, thanks, price transparency. I really just helped myself out there. If I tell him, hey, Adam, not only is there a $100 copay, but you're also responsible for 5% of the purchase cost. And by the way, it just so happens the $50,000 truck is actually 10 times better than the $160,000.
I'm buying the $50,000 truck.
That's why skin in the game and quality matter. And I don't see why. It seems commonsensical to me. But yet the amount of pushback I got when I said price transparency alone could be a bad thing, people went nuts.
Now I understand finally, after 10 years, why Ron drives Subarus.
There you go. I
never understood until now.
Quality and skin in the game. So, and when I talk about getting slammed online, this was the post I put online that got me absolutely crushed, where people say, price transparency rules, you suck.
Let's read Ron's quote. Get it. What does it say?
But until people are actually paying for some of the healthcare out of their own pocket, why would they care about how much something costs? And not only would transparency without skin in the game not necessarily have the effect we seek, but it could have a negative effect. And this is a concept, guys, that is proven in economics. It's a basic concept called the irrational consumer, where you could put two things in front of a person. It's the same exact item, and one costs more than the other. And even when they have skin in the game, even when they're the ones paying the cost, they purchase the more expensive item. Because in their mind, if it costs more, there must be a reason.
It's like Jen's outfits. They just cost more money.
Well,
They're not necessarily better.
She understands the quality metrics.
Costs more.
She understands quality too. But the thing is, and I couldn't give an example that's more on point than the following, and this is tied. We talked about drugs. We talked about healthcare. Adam, Brady, Jen, when you go into CVS or Walgreens, you go into the pharmacy, and you need a painkiller. You got a fever. There's the store brand, and there's the Tylenol. Why is Tylenol on the shelf when it is the exact same drug as the store brand, and yet it costs more? Price transparency, it's right there in front of you. Skin in the game, I'm the one paying for it, and yet people still purchase the more expensive drug.
What happens at your house when your wife comes home with Tylenol?
I can't go there. Please, TMZ is going to be knocking on the door.
Is this criminal or
no?
Are you okay?
I sent her back. Now, the thing is, the reason why people are buying the brand drug is because these brands like Tylenol and Advil have done an amazing job of muddying the waters when it comes to quality transparency. People will go in and they think that because the Tylenol costs more than the CVS or Walgreens brand, there must be a reason. It must be a quality thing, and I and my kids are not going to take low-quality drugs.
Poor Ron's kid, he's eating that generic cereal instead of Captain Crunch.
He's getting his Wegmans brand across the board generic.
Well, I'm gonna keep buying Tylenol, Ron.
All right, Adam.
Sorry.
And so that, ladies and gentlemen, is my point, that even when you have price transparency and skin in the game, without that quality transparency, you're still going to have people buying Tylenol. Wow.
Case dismissed. All right, folks, I've counted. We have like 60 questions. We cannot answer them all. There is no possible way. Our next webinar will be on April 19th at 1 o'clock Eastern Time. We have not decided yet on the topic, but I have a feeling that we're going to get a lot of emails from folks out there asking us what to talk about, maybe a transparency part 2. Who knows?
I can't survive another one of these.
There's a lot of people bringing up a lot of things. Again, I agree with Ron on the transparency piece. I agree with him on the quality metrics. I think that goes a long way. If people do know the price, they might actually spend more money because they're buying more expensive stuff so they think it's better than it costs more. Makes a lot of sense. That quality metric needs to be there. So join us on April 19th. On behalf of Ron, Jen McCormick, Brady Bizzaro, and myself, thank you all for joining us. I hope that we make it through another snowpocalypse tomorrow, and we also hope that Matt still has a job. Don't forget, #save Matt's job. Get us to 3,000 followers on LinkedIn. Thank you. Have a great day.